Secretary, Honorable Mr. Justice D.P. Wadhwa, Professor Dr. Ranbir Singh, Professor P. Pandey, Professor Caroline, and Professor J.S. Vajpayee. I am pleased to welcome all of you on behalf of National University Delhi. We have with us Professor Dr. Ranbir Singh, who was before he was invited to join this university, he was the founder director of Nalsa University of Law, Hyderabad, and has been at his helm since inception in 1998. Professor Singh's refined administrative capabilities and untiring efforts during the course of last 10 years played a critical role in reviving legal education in the country and recasting it so as to make it more relevant to contemporary concern. Professor Singh's greatest strength has been his ability to nurture the entire university community, faculty, students, and administrators alike, keeping the vision of the common goal aloof and providing space for the pursuit of the goal to each and all alike. Professor Ranbir Singh is also Last thing, sir. Professor Ranbir Singh is also concerned about making long-term collaborations that will help NLU Delhi in becoming the international hub of legal research and teaching in different areas. So now I would like to invite Professor Ranbir Singh to give welcome address.
Good morning, everybody. That shows we are a very strong mutual association society. I have the honor and the privilege to welcome Honorable Justice Sikri, Judge Supreme Court of India. So thank you very much coming to NLU Delhi on a holiday. We knew it that we can't say no. And in spite of the fact that he was very busy, he was shifting his residence. And you would know that when you shift your residence, what kind of things you have to do. But we were after him that you have to come to get this program. And briefly, Mr. Sikri was the Chief Justice in the Delhi High Court after being a judge for a long time. He was also the Chancellor of the University. And many things you find in place here is because of Justice Sikri. He has been a great help being a member of the General Council and the Chancellor. Now he's in the Supreme Court, but he even now takes a lot of interest. And one I can share with you is that I was struggling to have another piece of land, about 7 acres. I'm from Haryana. Haryana are basically land grabbers. My eyes on from a very first day were on 7 acres of land and joining my university, and I said I must have it somehow. And then that somehow could be possible only through Justice Sikri. He spoke to the Lieutenant Governor and said, probably you need to give this piece of land for future expansion of the university to NLU Delhi. In fact, sir, I was asking only for 2 acres. But Lieutenant Governor was so good that he gave all the 7 acres. When the minutes came, I was so happy now. The next phase of buildings for the expansion of the university will come there. We have Justice Wadhwa with us, former Justice of the Supreme Court of India. The entire program, today's program, is under the aegis of the chair, which is justice by him, and there is the chair of criminal law, and that could be possible because of Professor Pandey. He agreed to accept the chair professorship. For those who do not know, Professor Pandey has an experience of about 50 years of teaching in Delhi University, and any post you can think of in the university he had it. And then he eventually retired. He went to Lucknow and said, oh, I think enough is enough, and I want to relax with my family now. But then it will not be like this. We were again after him and said, no, as far as the criminology is concerned, you have to help us. We are a young university, you can't say no, and it is so nice of him that he agreed to join us. And all these programs under the chair, or we also have an Academy of Law Teachers where we have regular training programs for teachers in the field of criminal law, evidence. Those sessions are created under the guidance of Professor Pandey. We have so especially welcome all these guests present here. We have Caroline today with us. Thank you very much for you and for delegation coming all the way from Oxford. You saw in my room, I'm very fond of Oxford. And next time when you come, bring more photos for me. I would like to put in all rooms of my university. I welcome all my faculty members, my other staff and the delegates. Some of them are going to join us in due course of time. Maya Daruwala, a great friend who is director of CHRI, is not here, but she will be joining us, Devika, the program coordinator. And my legitimacy to be here in the inaugural function is because of the fact that when the country was thinking of the police reforms, I was a member of the Solidarity Committee, which gave that report. We prepared the model police act as per the guidelines of the Supreme Court in Prakash Singh's case. But unfortunately, when the states were given the model police act by the government of India and said, you need to rechange your police act in the light of this model police act. And unfortunately, not even a single guideline was complied with by any of the states except Kerala to some extent. And then again there was a committee, Kamal Kumar's committee, who was the former director of the National Police Academy, and a great friend of mine. I was also again a member of that committee, which concluded the second model police act recently last month, which has been submitted to the Ministry of Home Affairs. There the Supreme Court again asked us that tell us how many states have complied with how many conditions or how many guidelines laid down by the Supreme Court. So we found that hardly any state has done it. And they were very far-reaching reforms as far as criminal law is concerned. But probably let's see what happens this time, whether we seriously do it or not. I will not take much time, but I'm deeply probably tempted to read one paragraph to you, which comes from a book written in 1912. And the name of the book I'll share with you. I wrote an article long back for the NICFS. It's a very longest article which I gave to Monument also. And this was, the title of the book is The Little World of an Indian District Officer. And the name of the writer was the Castairs. And he says, I'll read this paragraph to you before I take my seat. Within quotes, in England, justice goes to the people. In India, the people come to justice. The litigant had to find his way to this strange tribunal in an unknown land as best as he could, in charge of the police, whose tender mercies he dreaded or alone. If he went alone, it was not for long. Around the courts were swamps of lawyers who had their touts on the roads and the villages. Longer he came within the hail of the court, he had been fastened upon by several of these, and persuaded that his only chance of success was to put himself in their hands, say what they bade him, pay what, when and where, to whom they told him, and above all to beware of telling the truth. It would never be believed. In those cases, there was no common ground. Whatever one side asserted, the other side denied. All the witnesses were tutored, and whether true or not to begin with, the case as presented both sides was invariably concocted. I, for one, came to the conclusion that nearly all, save a few graver cases, were episodes in some disputes not before the court. The parties were not the real parties, but puppets of others who remained in the background paying for and directing the proceedings. Most of the genuine disputes never reached the courts at all, but were settled at some earlier stage and in other ways. While we dispensed justice as best we could those who came before us, we knew that an enormous number of injured persons never came to the court. Many were deterred by the difficulties in the way. Many dared not come for fear of offending the local despot, who by threats of injuries, threats which he could carry out, was able to prevent them from complaining and to stop the mouths of the witness. Now, this is 1912. Now we have to say how far we have gone and what we have achieved as far as the criminal justice administration is concerned. I was not part, but I met Justice Swabinod when he prepared the report. He happened to visit my place at Hyderabad. That report was released in India by Hyderabad Law University. I also happened to visit his court. It was not the Supreme Court that time. It was the High Court, the Royal Court of Justice. So we are very serious about criminal law reforms. Probably this opportunity with Oxford University would prepare new grounds for us for collaboration, for research, for exchange of faculty, and probably This is what we look for. And with these words, I welcome you all once again, and thank you very much for coming to NLU Delhi and spending the rest of the time.
So thank you very much for your enlightening words. Now we have with us Professor Pandey, who is a trained professor of criminal law at National University Delhi, and he is a former professor of criminal law at Delhi University. Now I would like to request Professor Pandey to give brief introduction to the workshop.
Justice Sikri, Justice Wadhwa, Professor Caroline, Professor Ruder, and the whole team, and Professor Ranveer Singh Sahab, V.S. Bajpayee. Even before I assumed the chair, about which lot had been said, I knew as a visitor to the NLUD that something is a kind of program is on the way from Oxford. And one of the conversations that Krishna Dev Rao, the registrar, who was in touch with the Oxford team, was that mid-April, Caroline had sent a proposal for 3 possible sessions, idea of 3 possible sessions. One on policing and private security, the other on when criminal justice goes wrong, and the third on family violence. Obviously, criminal justice going wrong was so very relevant for our society. And I told Krishna that it has a lot of possibilities for criminological research and exploration. It is thoroughly underexplored theme. Therefore, we should clinch on when criminal justice goes wrong. And I do not know what happened later on, because the correspondence I was not in touch with, and how the Oxford team agreed to one core theme when criminal justice goes wrong. I understand that in the academic circles in England and Wales, already some critical writings of scholars such as Andrew Ashworth, writing in his Law Quarterly Review, volume 116, is criminal law a lost cause? And then Alan Norrie, in his book Punishment, Responsibility and Justice, that criminal justice system in UK and Wales is not possible because the basic Kantian premise has given way. The poor man and criminal justice system has become a means of state coercion against the poor man, against the resourceless man. Therefore, Alan Norrie's book and Ashworth's book were in my mind, and I thought that it was very good that Oxford team agreed on the core theme when criminal justice goes wrong. But my assumption was Oxford University participants would also focus on the core theme. But after going through some of their papers, I realized that they have laid much greater emphasis on empirical research on criminal justice generally. To them, empiricism is more important. You must test the criminal justice assumptions empirically before finding flaws in the criminal justice system. More important than finding flaws. To us, finding flaws is most important. because we have not yet theorized the wrongness of criminal justice administration, the miscarriage of criminal justice administration, the possibilities of grave threat to individual liberty, great threat to the whole social order through criminal justice system. Therefore, we decided that we go away, and I feel that is the beauty of a collaborative workshop. The beauty is we start from this side and you start from that side. You try to bring in more evidence. We try to bring in more crisis points. Evidence on those crisis points of criminal justice system is the core of this workshop, I feel. Our 2 days workshop and the third day of deliberations that are slated for deliberations of collaborative research, I hope will make the criminal justice system more, both of UK and India, more just and more rightful than wrongful to the citizenry of both UK and India. That is the hope with which we are going in for this collaborative workshop, and I hope you should all bless this collaborative workshop because the cause is noble. Thank you very much.
So thank you very much for giving us an insight to this workshop. Now we have with us Professor Caroline, who is a professor of criminology and director of the Center for Criminology, University of Oxford. I would like to invite her to give her address.
Thank you very much. First of all, and I say we, and I speak for all of my colleagues from the University of Oxford, want to thank the National Law University of Delhi for inviting us here, particularly to the Registrar and obviously to the Vice-Chancellor, but also to Professor Rao, who started this conversation, and to Anna, who's been incredibly helpful in setting up this next 2 days with us. It's true that there has been a little bit of confusion about what the workshop was going to be about, and I think that's largely about a change in personnel. I don't, however, think that we're a million miles from each other in what we want to do here. I'll come on to that. First of all, I want to tell you a little bit about the Centre for Criminology in case you're not aware of it. The Centre for Criminology is set within the Law Faculty of Oxford, but we're not all lawyers. Indeed, of the delegation here today, there's only Professor Loder who would confess to being a lawyer, and he tries to hide that. We come in criminology from a variety of backgrounds, from sociology, psychology, history, sometimes economics, although I don't speak for myself, but I'm not very numerate at all. And we draw on the law, we draw on the resources of the law faculty more generally, and we draw on criminal law, and we draw on black letter law at times, but we take a very much socio-legal approach to our work. And while we do care about empirical research, and while we do all do empirical research, we do it within a theoretical context. So we engage theory, empirical research, and we hope to also lead our research in the direction of policy relevance. So we're very much engaged in the law, in sociology, in policy, in social policy in particular, and we work quite closely with criminal justice organisations across the UK and indeed overseas. So we have close relationships with the police, with the prosecution service, with the prison service, etc. And criminology in England has a long tradition, going back to the 1950s, not that long I suppose compared to other areas of law, but reasonably long. The Centre for Criminology really was only established in 1976. In Oxford that makes us very young, but coming here where you were established in 2008 you feel very old. So that's the context within which we come, a very much a socio-legal theoretical approach to our research. So although it might look that we're very different, you have a very new law university here. We have a much older, more socio-legal approach to things. There are huge commonalities. Looking across your website, it seems that you're interested in very much the same substantive issues as us. And I think they coalesce around issues of social justice, concerns about social distance, about discrimination, about difference, about disadvantage. And that's something that I think all of our work speaks to. And so if you take the theme, when justice goes wrong, it's not for us just about wrongful arrests, wrongful prosecutions, wrongful imprisonment, albeit that's my particular area of research. It's also about when things go wrong within the family and how effective the justice system can be in those situations. It's about when things go wrong for people who cross borders but don't have the right legal documentation and how they can become oppressed and disadvantaged in a criminal process that doesn't really fully understand where it stands vis-a-vis what they would call irregular migrants. It goes wrong when the police behave in a way which is unfair or illegitimate to people, even if it doesn't lead to an arrest. So there are various areas of interest which, albeit on paper they might look quite different, I think when it comes to it, it's about justice not really working as it should, or justice not really working in the way that we would want to see it working. And I think that although we have two democracies, two old democracies, we have in India a huge population and all the difficulties that that raises for the state and the criminal justice process, and we have huge social distance. But it's not that those things are absent in the UK. It's not that everybody is equal in the UK. We have disadvantage and difference across gender, age, ethnicity in particular. And so we're tackling some similar problems, and I hope those are issues that we can tease out in the next couple of days. And so where do we go? I mean, this is a nice opportunity to have a 2-day workshop, but as has already been mentioned, we would hope that it would lead to further collaboration, further sharing of knowledge, ideas, expertise. And it's true, we do have considerable expertise in empirical research, and I'm more than happy to talk about it forever and a day. So we would be more than happy to continue this conversation beyond this week, to come back and talk more about our research, to collaborate on research projects. The UK at the moment is really undergoing a bit of a crush on funding for research. It makes it very difficult for academics, even in a privileged place like the University of Oxford, to secure adequate research funds to do work. And it might be that there's more money that can be unlocked by collaborative research with universities like your own. Certainly the research councils in the UK are very keen for people to do this type of collaborative research. So I very much hope that this conversation will continue over the years, and that other colleagues of ours will get an opportunity to come and talk to you about their interests, and that you would be very welcome to come to Oxford and talk about your research too. So I welcome this as the start of an ongoing collaboration over the years, and again, thank you so much for including us.
Thank you very much, Professor Carolyn, for inviting us to your university and for your encouraging words. And also thanks a lot for giving us an insight into the criminal justice system in UK and the kind of work undertaken in the University of Oxford. We have with us Honorable Mr. Justice A.K. Sikri, who is the Judge, Supreme Court of India, and former Chancellor, NLU Delhi. I would like to invite Sir to give keynote address.
My esteemed, I can say colleague also, even if he is retired, he still remains my colleague, and revered Justice D.P. Varma, our beloved Vice Chancellor, and Professor Caroline and her team, Mr. Bajpayee, my professor, Professor Pandey, all other who are present here. I was just thinking when my predecessor speakers were speaking that here is a rich faculty from NLUD and Oxford. These professors will come on a common platform and are going to discuss various nuances on when criminal justice goes wrong. and as Professor Pandey as well as Professor Caroline has mentioned about the scope of the discussions. And it is you professors who can undertake such research and can be critical of the system in a more meaningful way than me and Justice Wadhwa. At the same time, then it got, the first reaction was, or it came in my mind that maybe are we two who are the aliens in this workshop today? But then we thought that what we are discussing is primarily for us. Because as judges, we have to ensure at the end of the day that the criminal justice system does not go wrong and how we can salvage the situation. In the context, whatever powers we have, because ultimately adjudication is by the courts. But and therefore in this process, maybe I may not be that brilliant in my disposition and in my critique, but I can share some of my experiences as an advocate first and now as a judge, and being an insider in that sense, so that you can make use of my observations if they are found to be relevant by you people. Let me start with 3 examples, 3 cases. First is case of the trial of Kasab, who was a terrorist attack, you would be knowing, few years ago in Mumbai on Taj Hotel and some other establishments. And of course, other terrorists were killed and he was caught, and therefore he was put on trial. It took about 3 years, and after 3 years, of course, death penalty was given to him, and he was ultimately hanged. I still remember the day this hanging took place. In the newspapers, there were articles about this, and the 2 extreme views which were there. On the first side, there were certain citizens or other persons who had said, look, an episode or that event which occurred or that attack which went on, and if I don't know my colleagues from Oxford know it or not, but all Indians sitting here, they know, it went on for almost 48 hours, and it was entire thing was televised because the cameras could capture and it was coming live. With this kind of evidence, when everybody knew Kasab was seen and everything was captured, what he was doing, why it took 3 years? He should be hanged. He should have been hanged in 3 months' time. And therefore our system, judicial system or criminal justice system, is weak in that sense. This was the critical appreciation, or rather criticism of the system, where 3 years had taken place for a trial of this nature, where everything was so apparent. To a common man, naturally this would be the perception. On the other hand, there were articles by jurists and legal minds who said, look, India has set an example that we are a country of rule of law. Even if a person has committed this so-called crime and it is so apparent, but then he has undergone the entire process of trial, right from the trial court till the stage where because whenever the death penalty is given in our criminal justice system, it has to be confirmed by the High Court. Only then it can be executed, and then right to appeal is there, which was exercised by Kasab, and Supreme Court also heard, and not only when this case was heard, Supreme Court had provided one of the best counsel as by way of legal aid to Kasab to argue his matter, who is practicing in Supreme Court. So this shows that we are a country of rule of law, and howsoever may be the whatsoever may be the background of a criminal, but he is entitled to all the kinds of defenses which he can have, or the entire criminal justice system, which is the provisions which are made, which can be made use of by the defense, that are to be given to him. Now, this throws a debate, because the persons who were criticizing and they said that why he should not have been executed long ago, what we don't think of victims of the crime. And on the other hand, the other people who are saying that look, every person, whatever may be the background, every criminal has right of defense, which has to be given in conformity with rule of law. So we have the two conflicting interests. One in favor of the accused or the defendant who has committed the crime, that he has to be given proper defense mechanism which is there, and on the other hand we have the victims of the crime who have also to, it is to be seen therefore that the person who has committed a crime should not go unpunished. Second example I wanted to give, it's a case in America. In 1967, Mississippi court acquitted one person called Ernest Avantes. He was accused of murdering one Ben Chester White. The purpose of committing this murder was to lure, or I would say to force, the King Luther, what was his name, Martin Luther Jr., to come to Mississippi so that he can be assassinated. That was the purpose behind. But in 1967, Mississippi jury acquitted him. After almost 36 years, in 2003, he was convicted by the federal jury. Now, it is on the same evidence which was led before the jury which tried him in 1967. Interesting issue which arose was, look, it's a case of double jeopardy. How a person who is already acquitted in 1967 can be tried again. But then this was argument was discarded by saying that look, that was by the jury of the state. This is a federal jury. You know, in America, we have the federal system, and therefore they said that we are not bound by what the jury of Mississippi court did, and therefore the trial went on, and on the same evidence a person is convicted. I'll say this aspect when we come to the role of the judge, how same evidence, on the basis of same evidence, one court can convict and one court can acquit. But just see the travesty of justice. In 67, a person acquitted. After 36 years, in 2003, when he was 72 years of age, he was convicted and given the life imprisonment. Third is a case which I was reading. It's another interesting case, and what Mr. Caroline highlighted about the criminal justice system going wrong, not only when the cases are in the court. This is one Inam, a US citizen but a Muslim. He was prosecuted for federal racketeering conspiracy, where some funds were collected donations were collected in millions, purportedly for welfare measures like for poor, for these widows, etc. Those some programs. So these donations were generated propagating that, but ultimately were utilized and given to some militants in some other country. So therefore he was tried. Before trial, even the matter went on trial, his advocate entered plea bargain, and he accepted. Of course, in a plea bargaining in US, you know, and in UK also, that accepted for a lesser charge where the, and therefore he was sent to serve the imprisonment for 20 years. Otherwise, had it gone for trial and full-fledged trial for the offence he was charged, the punishment could have been, the sentence could have been 90 years in jail. But what I am trying to emphasize is, his lawyer gave a public statement why he accepted this plea bargaining. He could have fought this case and maybe he could have won also. But, and this is very crucial statement which he made, against a black person, that to a Muslim in US, where you will find impartial jury today. So I did not expect a fair trial, because jury person in a case like this, where the allegation is that the funds are given to extremists which are collected for this purpose, they would have not acted impartially. Now these are, I think, the three cases I chose for as an example to set the ball rolling and to see that how the criminal justice system and the three different facets, and how the criminal justice system works and how it becomes a casualty at times in certain circumstances. Now we know any case which comes before the court and it is tried before the court, because we don't have jury system in India, which was, of course, it was there when British India, we were a British colony, but in early 1960s we abolished jury system. So therefore trial, it is the criminal cases tried by a judge. But what happens whenever, and that is the system everywhere, whenever a crime takes place, first it is the police which comes into action, and it is the investigating agency which investigates into the matter. Then after investigation, challan or charge sheet is filed in the court, when prosecutor comes into picture and he prosecutes on behalf of the state and produces whatever evidence is relevant. Thereafter, defense is given a chance. He has, the accused or the defendant has right to remain silent, and guilt is to be proved beyond reasonable doubt. If the defense counsel thinks that the prosecution has not been able to prove the charge beyond reasonable doubt, I think it happens in India in 95% cases where no defense evidence is even led, because defense doesn't want to take that risk, and then of course judge hears the argument and pronounces the judgment. But at each stage, I would say, and which Professor Caroline also made a remark, and Professor Pandey as well, it is so crucial, and it is a step which would ensure whether the criminal justice system would work properly or it would go wrong. Our example, or our rather, I won't say example, our experience, the way police investigates in this country, it is very interesting. Let me before that say one thing. Our Indian Evidence Act is of 1861 or 62? 1872. So it was made during British time, and which is still valid law today. A provision was inserted in the form of section 25, which says that any confession before a police officer is inadmissible in, which is not even the provision in English law. But English people who enacted this act for India knew Indian police so well. And they thought that we cannot trust Indian police. Of course, I don't want to go into this debate why we have the Indian police of this nature, which continues even after 60, 70 years of independence, because much of that blame is even assigned to the Britishers who were ruling at that time. They wanted that kind of police for certain purposes, and I'm not going into that debate, but fact remains that this is, that we cannot trust Indian police, and therefore any confession, they knew it that police would extract confession forcibly. And if it becomes admissible in the court of law, then in most of the cases, innocent persons may be convicted only on the ground that this person had confessed. So what I'm trying to highlight is, and our experience has shown, that in many cases, investigation is not proper or shoddy. It is ultimately the investigating agency or the investigating officer who has to collect evidence and produce. In many cases, innocent persons are roped in, real culprit for whatever reasons. There may be various reasons, but again that's a matter of debate and long discussion. But then if a charge is filed against an innocent person is roped in and he's charge sheeted, and if ultimately the court acquits him, what is the fault which the court has committed? Rather, court has done justice, but in the process, criminal justice system has gone wrong because the real person has not been convicted, which is equally important. I'll read one or at the end few passages from a recent Supreme Court judgment given last month only on this aspect. Now, this shoddy investigation is a matter of concern. I tell you, there was a law researcher, law clerk working with me. She is now judicial officer, and at present she is posted as magistrate in Delhi. She came to me and started discussing. She is, I think, on this criminal jurisdiction as magistrate. She is there for about a year only, and she was so, I'm feeling so despondent and helpless. She said that even in 1 year's time, I have found whatever police wants to do, they are doing. They would file case, in many cases, the report would be filed untraced report. And we know it, that it is a report which is given because of so many other extraneous reasons. What we can do at the most? We will not accept that report. We'll ask for fresh investigation. After 2 months, 3 months, again report is filed against it, not raised. She says that even I tried, because an investigating officer who would be of the rank of sub-inspector or so will call the inspector, who is the station house officer, SHO, or even a higher officer, additional commissioner of police, or even commissioner of police in certain cases. But then ultimately we throw our hands off in desperation. That in how many cases you can do all this. So this is where the criminal justice would go wrong, when it is not even, a person is not even, a real culprit is not even brought to books and is produced in court. Now, second thing is, even when a person, and that is my experience again, and I was discussing with Professor Pandey the other day when he had come and he was telling me about this workshop, that look, what happens, shoddy investigation, here the person is, maybe because of the crime is such which has, it has invited the attention of media, and therefore police officer is little helpless, there is a pressure that you have to crack this crime, and therefore the person is arrested, but intentionally loopholes are left in the evidence which is collected and produced. And that is where many times, and I was saying where about shoddy investigation, the Supreme Court or even the High Courts have commented upon, ultimately acquitting the person. Then role of prosecutor comes. Relevant witnesses, if they are not examined in the court. Again, whatever statements I am making is from my experience. If material witnesses are not examined, they are left out intentionally, or maybe my mistake or foolishness of the prosecutor. Justice would be the casualty. Criminal justice would go wrong because the person would be acquitted. We have another problem which can be discussed in detail of witnesses going hostile in this country for various reasons. One reason could be that witness is won over. Other reason could be that we don't have any witness protection system in this country, and therefore the witnesses are threatened and they don't come and speak. Another reason could be that there is no proper atmosphere which gives the witnesses, particularly vulnerable witnesses, they are so terrified. The atmosphere in the court is so challenging that they are not able to speak. And take a case of a 6-year-old girl who has been raped, and the person, the rapist, is also in the court in front of her, and where she has to give the testimony, she won't be able to speak. And even, what to talk of 6 years old, even 20, 25 years old lady, for that matter. Take a case where it's a child witness and the dispute is between husband and wife. I'm not talking of civil dispute, there can be criminal case also. And he or she happens to be the child of parents. How she may have been tutored by the mother or the father, or she may be under compulsion not to speak. Suppose it's a case where it's a case of dowry death, in the sense which is very common in this country, where woman is murdered by the husband because she did not bring sufficient dowry or dowry demands were not met. And 10 or 8 years child is a witness. Now tomorrow they will say that, look, your mother has gone. If your father also goes to jail or he is convicted, where you would be? Who would look after you? So for various reasons, the witness may not come out and speak the truth. So these sociological factors may be there, but the justice would, this is again a case where justice would go wrong, where witnesses are not examined, witnesses are hostile, and these are the aspects I am talking, because this is so prevalent in Indian legal system or Indian criminal justice system. And then comes, of course, when the witnesses etc. are also there, everything, analysis of evidence by the judge and judge's perception. Another aspect before that I'll come, sometimes delays in Indian courts, where witness has come, not examined for some reason. One reason could be that, yes, there's so much of burden. If 40 cases are listed before a judge, out of which 10 cases are for evidence, it is humanly impossible to record the evidence in 10 matters in a day. So if in 2 or 3 matters or 5 matters evidence is not recorded and witness is asked to come again. Many times investigating officers, they get transferred to some other places, they are not able to come. The witnesses, the evidence also is lost. The witness may not be available after 5 years or 6 years or 7 years. There could be so many reasons. I give you one example here. And this was a case where it came before me when I was in the High Court. A lady had filed a criminal complaint against her employer of sexual harassment, and this under section 354. This case, 354, maybe one or two more sections also were there, and case was going on when it's a non-compoundable offence, but then we have the provision in our criminal code of criminal procedure that even in non-compoundable offences, under certain circumstances, when you find that yes, there are certain parameters laid down by the Supreme Court can quash the proceedings if the parties have settled the matter. But then that power is only with the High Court. So I was sitting on the criminal side in the High Court when this petition comes before me for quashing of these proceedings, which was jointly filed by that lady and her employer. I was a little suspicious as to whether she has given her consent willingly or under some coercion, some threat, or some other factor which makes the consent may not be, it may not be a free consent. So I called that girl to my chamber. I rose, went to my chamber, I said that I want to talk to her. I asked her that, look, I think it's, you are not threatened and because of that you have settled. She says, no, there is a free consent of mine. I said, you tell me frankly here, I'm not going to quote it or going to make it part of record, whether it was a false complaint that you are settling it now or it was a genuine complaint. She says, no, it was genuine. Whatever I had reported in my complaint, in fact, happened with me. And I said, why you are settling the matter? Why you want to settle? She says, see my situation today. After this happened and I lodged a complaint, naturally I could not have worked with that employer. It was a small establishment of maybe 20-25 people where that employer was there, maybe sole proprietorship concern. So I left the job. I've got a new job now. And recently I have been engaged. I'm going to get married after 2 or 3 months. See my dilemma. I had gone to courts, this case is pending for maybe 2 years or so. In these, the case came up for my evidence, recording my evidence 4 times. For whatever reason, one reason or the other reason, my statement could not be recorded. Now today, if I take leave and go to court for giving my evidence, and if my employer comes to know that I have filed a case against my previous employer, my job is threatened. I may be terminated by him also, because then he would become suspicious and he will say that, look, she has filed some case, it may be a false case, tomorrow I may be roped in and therefore my job is threatened. And in any case, I don't know whether the people from Oxford would be able to understand it or not. Our social conditions are such, but in any case that my fiancé, if he comes to know that I am entangled in a case like this, even my marriage is threatened. And these are the conditions in India which are still prevalent. So therefore, 4 times I had gone, evidence was not recorded, what should I do? I thought that, okay, let me buy peace and finish the case. I can't face this harassment of going to court again. Now, had I not asked her this, of course, I could manage the things. I dismissed that petition, directed I asked her, look, she said, I remember it was sometime in September, marriage was going to take place in January. I said, and her case next date was sometime in October or so. I said, if I ensure that your evidence would be recorded on the next date of hearing, thereafter you don't have to come because it's a state prosecution case and state is taking the charge of the case. You have to just give your evidence and thereafter you don't even come. One day you take some of leave and come to the court. I'll ensure that your statement is recorded. Then are you willing to still compromise? He says, no, I'll go ahead with the case because I want this man to be punished for what he has done to me. I said, then I, of course, gave certain directions, etc., without recording all this, which I could not have in that. But then I recorded this much, giving my, this delay has taken place, because of this, then the statement could not be recorded for, and that is a reason which has forced this lady to file this compromise petition, and therefore I am not accepting but directed that judge to record the evidence on the next date. And now this is the example I am giving, where many times a judge, he may not even be knowing what he is doing, may not be even sensitive to the consequences of not recording the statement in time, how it affects the criminal justice system or the justice which should have been given to that victim. So these are some of the examples, and then it comes, here we have a very, again, peculiar system in India. Our prosecutors are not, who are on state rolls and paid by the state, may not be that efficient and competent as many defense lawyers who appear on behalf of the accused persons or defendants. But then this battery of lawyers who are top-notch lawyers, their fee are very high, and they are engaged only by rich and famous if they are involved in some criminal cases. Now, on the one hand, we have this kind of prosecution team vis-a-vis those defense lawyers, where it is not a level playing field, so to say, in the court. They are no match to these defense lawyers. And on the other hand, we, of course, Indian legal system provides legal aid to a defendant who is not able to afford, so defense lawyers are provided. But they are also not very good. Now, vis-a-vis that prosecutor and this, now there is an imbalance when it's a case of a rich person. Defense lawyer is much better than a prosecutor. When it comes to a case where a poor person is tried who is not able to afford his lawyer himself and provided a lawyer, his defense lawyer in comparison with that prosecutor is much less competent. So therefore, whereas on the other one hand, and that is sometimes this impression is given, look, rich people in this country, they go scot-free. That is generally of course, there's some other impression also developing where some of the famous persons are given very harsh punishment for what they have done, that look, the courts are unjust to these people. There are few examples. Salman Khan was when for killing that deer, was for killing a deer, sentenced for 5 years because imprisonment, and only because he is a very famous Bollywood actor, a celebrity. That is why there was a criticism of the judiciary that maybe he is convicted because of his position there. So of course we have that also, but general impression is that look, on the other hand, poor doesn't get a fair trial in this country. I give you two examples of a defense lawyer who was provided and what kind of foolishness they did. One was the case, and again, I mean, both the cases came before me. One when I was sitting in the High Court, and other in the Supreme Court. One case was where a boy, 21 years old boy, was accused of murdering and wiping off entire family, consisting of naturally a husband, wife, their 2 children and 1 servant, who was only 12 or 13 years old boy. He was also a domestic servant in the same family. And one fine morning, it was found that all 5 dead bodies were found and this person was not. His defense was of LIV, that I had taken leave for 5 days ago and had gone to Nepal, so I was not there on that fateful night. Now, naturally, I'm not going into the details, evidence-led, etc. But the one prosecution witness was a motor mechanic who had been examined and who had deposed to the effect that the previous night he had gone there, and because this man had given his car for repairing and he had gone there to give back that car, And he says that I parked that car and went to that 7th or 8th floor in that building where the victim family had their apartment, and I had given that key. And when I was coming back, I saw this boy. He was there. So they wanted to show that he was there on that day, and it is not that he had taken. Now, in the cross-examination, although defense, as I said, that they were saying that he had taken leave, etc., he had said that he was sleeping in the veranda when I was coming down. And the question asked to him is a foolish question. He says, no, I mean, sometimes defense lawyers think that they have to cross-examine on every and all aspects. He says, no, he was not sleeping. He came down just to see you. Now this question shows that yes, you are accepting his presence there. And entire plea of alibi was, thereafter rejected on the one question of defense lawyer only. I have seen many times the defense lawyers, they don't even think where to stop the cross-examination. Second case was a rape which was decided by us a few days ago only, maybe about 15 days ago or so. Rape of 8 or 9 years old girl. And there was no other evidence, no corroboration except the statement of prosecutrix. But the doctor who had examined medically after, he had also stated in his evidence that she is mentally retarded. 8 or 9 years old girl, mentally retarded. Now I'm not on that whether he committed that crime or he did not commit this crime. I'm only on the foolishness of the defense lawyer. Now once it has come on record that this is a mentally retarded child and only 8 years old, for a defense it was very easy to say that look, whatever she has stated should not be believed, because she didn't even know what she is saying. It is your own doctor, prosecution, the person who has examined. But then the lawyer starts cross-examining and doubting the statement of the doctor that no, she is not mentally retarded. So you are yourself saying that she is not mentally retarded, and if you accept that fact, then the law is very clear. If a 9 years or 10 years old girl, if she has, and she is a prosecutor, if we can, of course, it's a child witness, but if she is reliable, then the testimony of the prosecutrix is sufficient to convict a person, and the person was convicted. So these are some of the aspects which you can go into and look about it, and discuss about it. This was my, endeavor to say in these few words my experiences and share. Of course, then we have the problem of, nowadays, and I think one of the sessions of yours is also there on sentencing policy, where now we are going from rehabilitation to incapacitation, etc., whether it is correct, and that the pendulum is, going from one side to other time and again, and this is the problem not only in India but elsewhere also. On shorty investigation, at the end of the day, when we talk where the system, criminal justice has gone wrong, what happens if the person who is the innocent person who is roped in, and the court acquits him? To that extent, it is justice done to him. But what about the rights of victim? Where is the real culprit? He should have been punished. There is no mechanism, and there is nothing to ask the investigator to now look into and investigate this crime and bring the real culprit. There is no system. On the other hand, if a person who is innocent and has been ultimately acquitted by the appellate court, and suppose he was convicted, or even he is acquitted by the trial court, but as an under trial prisoner he remained in jail for 1 year or 2 years. Even if he is acquitted, ultimately justice is done to him. What about his wrong or false incarceration for those 2 years which he has suffered? There is no provision for giving him any compensation for that. So neither we have the provision for compensating the victims, nor we have the provision for compensating those who are wrongfully made defendants and suffer this criminal justice system. And that is what I think, because I am running out of time, I can only give you the citation and very beautifully written passages from the state of Gujarat versus Kishan Bhai 2014, 5 SCC 108, and where they have said that it's a case again of a rape of a girl, a small girl, but the person who was made defendant was found to be innocent by the Supreme Court. But then they have the anguish is expressed in saying, what about the rights of the victim and the family, because the real person has not come, and it has all happened due to shoddy investigation. And the Supreme Court has given certain directions also as to what should be done in such circumstances. I wish good luck to all of you, and I request, it is my request, that whatever are the deliberations, you please send it to me. We will try to make use of it in our judgments whenever we find an occasion. Thank you very much.
Thanks, sir, for giving us a glimpse of Indian justice system and how and when can it go wrong. Thanks a lot for sharing your enriching experience with us. Now I would like to invite Professor Dr. G.S. Bajpai, Registrar NL New Delhi, for giving vote of thanks.
Well, this workshop has taken up such an important issue, and I am reminded of the history of criminology, because you all have a tremendous criminological understanding of the subject. I find three phases of criminology, and I think where we draw from this particular workshop. Criminology started with its focus on crime, and subsequently we have shifted the focus to the criminal, and therefore we saw a lot of rehabilitation and treatmental programs coming up. And in the third segment, we find that criminology has now started focusing on system, and therefore this workshop. Because in this workshop, we are questioning the system, and the entire developments in critical criminology, especially questioning the system, policies, policymakers. And I find this workshop to be an extension of that intellectual pursuit, which is very well rooted in the criminological enterprise and criminological imagination and criminological thinking. And therefore, when we say system going wrong, essentially we are talking three segments, and probably our discussion and the papers that we have selected are revolving around those three things, whether it is the law or legislature, which we are talking about going wrong, or it is the agencies or institution of criminal justice, or it is the functionaries and individuals. So at three levels, this discussion can revolve, and I am sure that after the very enlightening and very, very engaging keynote address of Justice Sikri, he has already flagged very important issues, and this reminds me a lot of writings which are coming up from US and UK. We have procured all those writings in our library, and we all have occasion to go through. I find his ideas, interspersed in all those writings, and especially the one which Richard Leo's work I was reading last night, and he was also saying that it is the pleading of the police which is, relied upon by the courts and prosecution all the time. So if police doesn't do well, because all the evidences are collected by the police and they are relied upon by the prosecution and relied upon by the court. So it becomes very important. And in the US, the recent book called The Denial of Justice by Venerum, the idea was floated that the police is also the victim of unrealistic expectations. Police is really not doing enough because they are not doing quality investigation because they are loaded with a lot of law and order duty functions. So therefore, I think this discussion is going to be extremely significant, and from individual going wrong, this was the major engagement so far. Individual police officer, individual prosecution. Now we are looking at system going wrong. So this is as Professor Pandey also said, this is relatively an explored area in terms of empirical research. Though some studies have already been appearing, and I am seeing a very important Supreme Court judgment given in 2014, and to my pleasant surprise that the Supreme Court in this judgment is saying
that every criminal case ending with the accused being acquitted will have to be examined by the state government to ascertain whether there were lapses by the police in prosecution if the accused was deliberately framed. Now, this is the line which has tremendous policy input for the state. The state has to necessarily look at the cases resulting into acquittal. And for me, most of the writings, I think you all would agree, they are titled on wrongful conviction. But in Indian context, the wrongful acquittals are equally important. So wrongful acquittal, we are also engaging it because shoddy investigations may result into both. It may result into wrongful conviction, it may result into wrongful acquittal. And it becomes a matter of interesting and very critical inquiry into these facets of criminal law. And I'm sure that your presence will boost the ideas and researches on these subjects. And my job at the moment is to offer my vote of thanks to begin with to Honorable Justice Vadvaji, the former Judge Supreme Court. And in fact, this program is being conducted under the aegis of late Shri K. Arora, Chair of Criminal Professor. Professor B.V. Pandey is here, is the anchorman of this program. And you believe me, for last many days he is sitting with late in the evening discussing on small points, and he has changed our style of thinking on these subjects in past few days. So thank you so much to Justice Vadvaji and Professor Pandey. And we have also, I acknowledge the presence of Honorable Justice Shri A.K. Sikri. He has been the source of great inspiration to this institution, and it is always good to be in discussion with him on any subject. And the range of issues that he has flagged in this morning and his very brilliantly done keynote address, I think I'm sure we are going to be benefited, and we assure you, sir, that we would be taking it up in some form of research or some form of deliberation, and we'll get back to you with the finalized volume of proceedings and documentation of all these ideas to you. And I also take opportunity to thank you, the Oxford delegation, especially Caroline and her colleagues, Professor Ian Roder, Dr. Rachel, Dr. Alpa Parmar, Dr. Ben, Dr. Sarha. All the eminent people are in our midst, so I'm sure this session is going to be, these next sessions are going to be extremely brainstorming. And I also take this opportunity to thank the partners to the organization of this conference and this workshop, the CHRI representatives, Ms. Maya Darwala and her colleagues, Devika is here. And I also take this opportunity to thank Ms. Donna John from FNF. They are here. They have also been a constant support to all our endeavors. And I also take this opportunity to thank the team which was working behind Dr. Bharti and her associates and the students, dear faculty, and of course the staff members. Despite, so this is a vacation time in NLUD, that's why you are finding it an aesthetic thing. But so students are not on the campus, they are observing 7 days off. Off days are very rare on this campus, so whenever they have opportunity, and the staff is also enjoying, but for this particular program they have returned, so the staff also deserve thanks. And of course, there is no need to mention the continuous guidance and patronage of Professor Ranveer Singh, the Vice Chancellor of the University, who has been a great motivation to all of us to host this kind of functions on this campus. Friends, here I break, and we'll join a cup of tea over here.